I'm attorney Justin Sterling. I'm personal injury and business lawyer. This is Coffee with a Lawyer, streaming live on the digital airways of YouTube, Facebook, Instagram, and LinkedIn. This is your chance to ask the lawyer your legal questions for free. This is our pro bono legal service. This is why I do what I do to help people deal with legal issues, improve their lives, and make a meaningful difference. Please know there is no attorney-client relationship. There is no confidentiality here because we are streaming. There are other participants. The information disclosed here could be discoverable in any legal matter. This is only meant to be general information and is not specific legal advice. I encourage you to keep the questions general and not be specific. If you need to speak about your specific details, it is best to schedule a confidential consultation with a lawyer. And today we have a special guest. Brian, would you like to ask your question, give some background, maybe bring up a topic you'd like to talk about, and I'm happy to be of service.
Yeah, I'm not really sure myself how much you would want me to go in or how much I should go into it, but I'm certainly, can give you some details. I'm not sure what part of this has already, been a part of the public record. I'm not, I'm a fairly transparent person, but, obviously, I'm looking for some potential. I think the best path would be through litigation with an insurance company that I believe has defrauded me of insurance coverage. And it just turns out I did mention to you this email I got regarding non-renewal. I have discussed it. I think maybe I discussed it with you, but also with other attorneys. And, they first go into whether or not, which is a legitimate thing that I thought it was a legitimate non-renewal. It turns out to be fraud. It turns out that the insurance company that this gentleman claimed that I was non-renewed, they claimed when I made a complaint to the insurance commissioner, they said, "Oh no, we didn't non-renew you, and oh, by the way, we sent you some, renewal notices or invoices, to your New York address, and you just simply never paid your bill." So, which of course I never got those because I don't believe they in any way sent them, and they had submitted no evidence that they actually sent them, who sent them, when it was sent, etc. But anyway, so that's really the case. The insurance commissioner did not accept the case. They incredibly, they're very low ranking employee. Apparently, she concluded, I don't know, she has no law degree or anything, never represented as such, but apparently used to work for insurance companies and decided that non-renewal email, which was the only information I received about it, was a mistake. And I just need to point out that neither the insurance company itself nor the gentleman, the broker / agent, ever said it was a mistake. She concluded it was a mistake in order to come to her conclusion, which was that I just simply didn't have insurance coverage, and so I'm just SHIT out of luck. And I guess so. Any insurer, any homeowner in California now can, I guess, get an email from their broker agent saying they were non-renewed, and then I guess letters could be purported to be sent out that controvert that, and so coverage can be lost. I guess class action. And I would just point out this same insurance company ran almost the identical scam of non-renewal fraud, like one or 2 years earlier, and in fact was indicted by the insurance commissioner. So I do think it would be a potential RICO case, because I think this is a series of frauds that wire and mail fraud, and so I am looking to be represented in such a situation.
Okay. So first off, I would suggest that you obtain insurance coverage and alternative coverage. So you have some coverage right now. So there's no question about that. I don't know if it's an issue whether you need insurance coverage or not, but it's always best to have insurance coverage at the moment. And I don't know if that's your situation, whether you still need coverage at this moment or not, if it's relevant, because I believe it involves the home. All right. And I don't know what your situation is at the moment, but that's one suggestion right now is seek alternative coverage. You would have to get your policy, review the insurance policy with critical scrutiny. You really have to dissect the language. Now, of course, they should have provided you notice. I know they're claiming they have sent you correspondence. You're saying you didn't receive it. There should be some proof of service. Did they send it by certified mail? I know there's this argument of the email. I don't know if that will be sufficient. Is that a method that you opted into when you purchased that insurance? I don't know. That's something to explore. So yeah, you have to really identify the policy and the language within the insurance contract, and also review the notice statutes that apply to this type of insurance. Does that make sense?
Yes. Yeah, a couple things, Justin. Thanks for your assistance. The home is gone. Every single home
Right.
in that property burnt to the ground, and there's nothing. Some of the people actually, I have, been in discussion with them. They do tend to carry over their insurance, despite the homes. None of the homes there existing. I haven't done it. I guess I didn't really go into it, why I wasn't able to get insurance from an alternative insurer, or was Geico, because they, at the last, was, I guess, not an unreasonable request, but they asked for specific pictures on specific parts of the homes, which I had, but those pictures were 13 months old at the time, and they said they had to be less than a year old, and I wasn't in Los Angeles at the time, so I wasn't able to take those pictures. And, I was trying to figure out a way either to get those pictures taken. Obviously, I would have to let someone be admitted into my home and so on. And I just wasn't able to get that done before the fire. And, that was that was the problem. I mean,
so I want to just clarify, the non-renewal occurred before the fire.
Absolutely. It was
Right.
Exactly. It was.
Because I do believe there is some moratoriums on cancellations as a result
Yes.
of the emergency fires. So
There was exactly that. You're absolutely correct. The insurance commissioner did exactly that. And I guess the argument was in front of with the insurance commissioner, this was, their legal argument was that, oh, they never non-renewed me. This is the incredible part. This is the shocking part, Justin. They never non-renewed me. That they never explained themselves. Obviously, the insurance commissioner or his staff came to this conclusion. Oh, it's just a mistake.
Okay.
So, no harm and no foul. You
Yeah.
just lose your home. So that's a harm and no foul. But
Yeah.
it's
Well,
just me.
Okay. Here's what I'm thinking. Here's what I'm thinking. Don't stop there. Okay. The insurance commissioner denied the claim. All right. Now you have a few options. You can repackage your claim somehow and resubmit it. I don't know if there's an appeal process with the insurance commissioner, but ultimately, I believe you will be ending up in court. Now, I don't believe it is a claim for fraud. Everyone wants to allege fraud all the time. Fraud this, fraud this. No, I think for your specific case, it would be a breach of contract case. All right, a declaratory relief. You want to seek declaratory relief about this non-renewal issue, that it was not submitted. You did not receive. It was defective notice. All right, that's going to be the basis of your claim. Defective notice, and you want to seek declaratory relief that you had coverage, an order by the court saying that the notice was defective and you should still be covered, and you want a breach of contract claim against the carrier.
Yeah, I mean, just all I'm seeking, because obviously I did mention RICO, because obviously there's triple damages. I'm not trying to, one of the things I
time out,
to them is
time out, time out. Look, you're trying to expand. You got to really plead RICO causes of action carefully. All right. Because when you start alleging RICO, all right, it starts expanding it. And then the court starts looking at you skeptical. And then you open yourself up to the argument by the defense, like, look at this guy, he's crazy. You want to avoid that. Let's keep it specific to your case. It's a breach of contract case. Defective notice.
Well,
RICO.
I totally agree. It is,
I mean, you want to be careful when you're starting to allege RICO. Every time when someone hears RICO, they think of the mafia. All right, it's just inherent. That's why they created the RICO statutes. All right, in the criminal realm, and then also civil RICO. But we're not. You really need a lot of manpower to start alleging RICO. It's just they're going to look at you skeptical. But if you keep it really concise and to the point, breach of contract, the carrier is breaching their contract with me. That's clear. It's logical. It's reasonable. Defective notice. All right. Do they have a proof of service? Did they send it by certified mail? Do they have proof I opted into email service? They didn't serve me notice of cancellation and I lost my home. Now they're trying to get out of it. And they have a duty of good faith and fair dealing with me in this insurance contract. Breach of contract. It's a strong claim. It's a much stronger claim than RICO. You're not going to win on a RICO claim. You might win on a breach of contract claim.
Right. Well, I certainly agree, Justin, that that's the easier claim. It's probably the more logical claim. And I'm just, a couple questions. Thanks again, of course, for helping me here. Now, with a breach of contract claim, would I be able to recover attorney's fees?
It depends on your insurance policy. You very may well. But here in the United States, it's not like other jurisdictions throughout the world where the prevailing party gets their attorney's fees paid by the other side. That's not our system. Unless there is a specific statute, and that's why you may want to research the notice statutes in California in terms of being provided notice of cancellations of your insurance. That I would have to do some research into, and I suggest you research that too, because there could be a fee shifting provision within those statutes. And if that's the case, then you can allege and plead to recover your attorney's fees. Or there's a provision within the contract that says that the prevailing party should have their attorney's fees paid. That's the only available means to have your attorney's fees paid here in the United States jurisprudence, is to have a statute or a contract provision. So you have to look and see if you have those. Even still, it's very difficult to recover attorney's fees because at the end of the case, you have to motion to the court and get a judge to grant attorney's fees. You have to prove them up. And courts will scrutinize them with a critical eye because they're not apt to award payments of attorneys. Judges it's just not within their nature to do so. So they're going to really scrutinize it. Does that make sense?
Yes. And I just want to mention that, in this particular case, I 100% agree with you, of course, about the breach of contract, but this is not, a typical, even non-renewal. I understand you, saying maybe fraud is not the correct word. I certainly don't know any other word I could apply to this, because this is different from, I think, any other situation in the case law, because here we had, the broker slash agent, the only person, in everything I did was online with them. I signed the contract, I got emailed the policy, all communication was done by email, whether I opted in or out. That's a very good point, and certainly it's something to discover. But as I said, they sent this non-renewal email. This gentleman, as for representing the insurer, and of course it was not legal because it was insufficient time before the expiration. It was only 3 weeks before, and it had to be 60 days. And you could tell I discussed this with other attorneys, so that's how I knew. I'm not an attorney myself, but they told me. And it also had to have a articulable reason. They gave no reason. Blaming the insurance commissioner, I thought would maybe get the insurance commissioner to maybe more likely accept the case. I don't know why they didn't really, but ultimately that was their decision. And, I did ask what the appeal process is. I put in a FOIA with the insurance commissioner, and I received no answer for it, not even an acknowledgement of it. I did suggest there's some hijinks. I made a complaint to the inspector general there about their behavior, which I considered extremely biased in favor of the insurer. It's different. It's distinguishable because I said, it's kind of hard for me to even grasp it myself, but the insurer said they did not non-renew me. And they just didn't explain the relationship. If they told Mr. Hughes is his name, Chuck Hughes, whether they non-renewed me, whether they discussed it between each other, or what. They just said,
well, sir, I do just have to just remind you, let's not reveal any identifying information, because what we say here could be discoverable. Okay. So we do have to just speak in general terms here. Again, I have to refer back to the disclaimer, because this is a pro bono service. This is not confidential. So we have to be mindful of not getting too much into specific details. I will say this: you have an uphill battle with the insurance companies. This is their business model, is to deny, delay, and deflect, which they're doing. You're within their ball game here. It's been their model since the beginning of the times of insurance and the insurance era. It could be considered probably the biggest scam there is. All the premiums you're paying, and then when it's time for them to show up, they give you some nonsense argument. So I have a lot of empathy for you. This is what I do, is battle the insurance companies. It's going to be a lengthy process. I do think you will find yourself in court. Try to exhaust your avenues with the insurance department. Try to get the commissioner to see the facts. But with these residential fires, the emergency fires, they're overwhelmed. I really haven't heard of anyone who's gotten paid by insurance yet for these fires. And it's been how long? Well over a year, 2 years almost, right?
I do. The Pacific Palisades fire is not quite a year yet. And I do think some of I've been told, it's certainly not me, of course, but that some people did get paid. That the insurance commissioner did.
Which carriers?
Instruct them to do a max payout.
Yeah. Which carriers made payouts? Do you know?
So I don't. I'm sure that they haven't done all the payouts that they should, but I can't say they haven't done any. But because in my case they're saying I just simply didn't have insurance coverage, and I would just point out to you one other thing, just which I raised with the insurance commissioner, which I'm sure you're familiar with as an attorney, this idea of unjust enrichment, that somehow, even accepting their argument, oh, this guy just sent a mistake. He wanted to send it to somebody else. And, I don't know. They didn't explain to me why it was a mistake. What was the mistake? But let's say it was, and then they profited of approximately $600,000 in not having to pay out this insurance coverage.
Well, these
And,
are all
obviously
these are all
there's
fair
that.
arguments, but I want to ask, and I know you're working with counsel already, which is good, but I think you got to get into court, and time is of the essence with statutes of limitations. So, what is the status of filing? What's going on there? Because we can talk theoretically about all these,
Oh, absolutely.
all
you're
these
right.
arguments and everything, but time is of the essence.
And as I said, I have spoke with some other attorneys. I was given some information that I turned out maybe not to be correct. One of the attorneys that I actually got pretty far into this with, she thought that the first statute of limitations would have been, I guess, mid-November. Obviously, that passed.
Yeah, that's why I brought it up. I'm concerned. It's a year.
That 1 year after
year of a written contract. So
basically the false or fraudulent, I think I would call it anyway.
That's why I brought that up, because we can go back and forth about all these theories, but you're just wasting time. Get into court. That's that's my advice. Let's get into court.
I do want to get into court. It's always better, as you know, of course, to get into court before the statute of limitations, and of course you can't even try afterward. But just from my information, that all, when I kind of got bad information, frankly, from ChatGPT, that apparently all the relevant statute of limitations are 2 years or more.
Well, I believe in your situation, it may be 1 year for a written contract. I don't know. We'll have to research the statute.
Maybe.
I mean, what was the statute that you just referred to that you said passed in mid-November?
Well, yeah, see, I wasn't, this one attorney suggested that for some, potential claims, she thought that 1 year, she didn't say which claims. I don't know, maybe that's the claim you were thinking of. And I wasn't able to discover, I don't know what the law is, for breach of contract in California. That's a great, that's obviously a great legal question. But when I try to confirm what I was initially told, I actually I ran with the one year thing, and I was not able to get anything done, filed in court. I'm not in California myself. I couldn't even do it pro se, even if I wanted to. But I just simply wasn't able to do it. And I did try to confirm. Obviously I don't want to sleep on my rights, and I it seems to be anyway to be 2 years for these types of complaints. Obviously, depends on what the what the legal principles are that we would be going, that I would be doing. And maybe I need to take a deeper dive in this, because I wasn't necessarily looking at it as a breach of contract, but I think you're spot on about that. It's certainly something I just neglected, I guess. But yeah, so
well, I do have to just remind you. I do have to remind you that's not going to be a defense to inform the court that you just neglected it. All right. Ignorance of the law is no defense. We have to do research into the statute of limitations. That's always the primary thing you got to research. Now, you could still be within your period. You may want to look up some codes of the Code of Civil Procedure. I'm doing some research right now. There may be a 4-year statute of limitations.
I know that suing the state or the city or those were, I think those are a long past. I think it's something like 6 months or so.
Well, right? Look, that's a whole different ballgame. You're not suing the city or the state in this type of fact pattern that you provided. When you are suing when you're trying to assert a claim against a public entity, yes, there are very strict time limits. You have to provide them notice of a claim within 6 months, and then they have to review it. And then once you get a rejection, then you can file a lawsuit. But yeah, very short time window when you're dealing with public entities. But let's not get that confused with what you're trying to do here. You're going against a private carrier.
Right. Yeah. So anyway,
Okay.
obviously there's, obviously a lot more detail.
Yeah.
There was, correspondence and so on. But that's really, the gist of the case. I can certainly, I don't want always try to make it more complicated, but I guess, it does happen to, occur, a lot of detail, I guess, not a lot of detail, but certainly some. But that's pretty much the parameters is, basically that the one email, which they acknowledge, they never denied, that email was sent. They never denied that, I never got the communications, I just asked for discovery, via the insurance commissioner, especially, via the FOIA request, but also within the complaint. Or actually I made 3 separate complaints.
I don't understand what you're trying to get at with the Freedom of Information Act, and who you sent that to. You sent that to the insurance commissioner. I don't know what you would get from them. This is involving you and an insurance carrier. That's not a public entity. You're not going to get Freedom of Information Act from them.
Well, the insurance commissioner is a public entity, and
but what do they have of the private entity, of the private carrier?
They were the intermediaries that
I understand
between the insurance, and they in fact informed me who the actual insurance company was, which I didn't even know because I understood him as King Insurance, but
I understand. I believe that you are really burdening yourself with a lot of extraneous activities. Again, I see this as a situation between A and B, you and the carrier. You got to get into court for breach of contract. They are breaching their contract with you.
I totally agree.
So cut this nonsense out. You're beating your head against the wall trying to argue against the insurance commissioner, sending them Freedom of Information Act. It's red herrings. It's irrelevant. It's extraneous. This is a breach of contract. This is a matter between you and the carrier. Let's get it resolved. Let's get into court. Things to do. 1, research the statute of limitations. All right. 2, let's get a complaint drafted. Get into court. All right. Time is of the essence. You're only going to get things answered. You're only going to get responses to discovery when there's legal obligations. You can send all these letters saying, I want this, I want that. You're really wasting your time. You are falling into their strategy of delaying. Delay, push, back. Let's hope they don't file. All right, that's what they're doing. All this is just, let's just hope that they get fatigued. Let's hope they lose interest and they get fatigued and they move on. Let's hope they do not file a legal complaint.
Right. Let's say the insurance company.
Yeah. Let's hope that the statute of limitation is blown. What we need to do right now, you have to really research the statute of limitations. And I know you spoke with some other counsel, and rule of thumb, 1 year. That's the short statute. Let's meet the shortest statute that could be argued. It's a 1-year statute. Generally, civil claims have generally a 2-year statute, but let's not gamble on that. There's arguments to apply depending on what causes of action you're asserting, how you're trying to argue your case, what statutes apply. Let's just meet the earliest statute, 1 year. Let's not even make it a question. You got to file, promptly. I understand that, perhaps whatever statute you guys are arguing applies could have been already passed. Just get into court. All right. Let's get something drafted. Let's get into court. You got to get into court. because
Correct.
all this time, like, you're falling into their strategy, hoping you get fatigued, hoping you blow the statutes. Even when you file, it's still going to be another 2 to 3 years. Might as well get the clock ticking now. File.
Right. Well, I'm just, I am concerned about the cost of the litigation, and obviously, if it has to come out of my pocket, when I believe that they've intentionally wronged me, I don't see that. Unfortunately, I'm just trying to get myself made
Yeah,
whole.
I
All I want
understand.
to do is get it as if, they didn't commit this. If you allow me to use the term fraud, because I can't think of any other term. The fraud that they committed against me.
Breach
The
of their
harm.
contract.
Let's just call it let's call it the harm. The harm of me, losing my home and not being insured, and just losing, my, a lifetime of investment of savings, paying, insurance fees out of my share of what I should be getting already without any cost. Obviously, I'm not being made whole. See, that's part of my concern, and I don't want to go into it losing even if I win. You see what I'm saying?
Well,
That I'm only going to receive a fraction of what I should have gotten. Obviously, that's one of the reasons why, even though the RICO issue is, I understand that perks people's ears up, and maybe it's a waste of time, but obviously
yes,
that's something
but
that,
you bring up a
they
good
can
point.
go
Yes,
consider that
you
as
bring up a
option.
good point. Which statutes, which causes of action may allow you to recover attorney's fees? I understand that. You bring up a good point. You have to review your insurance policy. What does it say within the policy? Tell me this. Have you actually read that insurance policy word for word, first page through last? Be honest. Most people don't, because they're very lengthy and they're very obscure, very difficult to interpret an insurance policy contract. Do you even have it? Have you
I do
ever?
have it, and that's obviously a legitimate question. I think I would say I skimmed it. I'm
You
probably one of
have
those
to
people
read
who's
it.
more likely to read something like that than not. But I can't say I read every word, because I took it as a take it or leave
Have
it
you
contract.
requested the exclusions and the exceptions
I did
in
make
all
some
schedules?
requests.
You got to make sure you got everything, all schedules, all exclusions, all exceptions. Request that from your carrier. You're entitled to have that. All right, that's not something you got to serve discovery.
No, I do have it. I believe, unless there's some additional documents, that I should have and don't. I don't know that's the case. I do have, it's a long policy. I don't know what it is, like 30 pages or something. And I'll probably just gonna, if I didn't read it, or I did read it, maybe I didn't read it correctly, and I'll certainly take a deep dive into it and what it says about,
Well, let's have an attorney review it. All right, and I'm happy to do that. Um, Something you can reach out, but let's have a professional review that insurance contract. It controls a lot. I do want to just interject and remind people that this is pro bono. This is at no charge here. There's other services that may go beyond this, that may require consultations or further services. But I'm here every Monday, okay? And this is a good place to tap in to just at least stay accountable, to make sure you're making progress, because legal situations are difficult. They take priority. And so I'm here every Monday so that you can at least focus and attack those important legal issues for the week ahead. Now, I may not be able to provide you service, but I will do my best to get you to the person who may, an attorney who may. So please feel free to reach out beyond this platform. Also, although you're not required, but I would be truly honored and grateful if you were to leave a positive review, because this is a platform in which I am volunteering and providing pro bono services. You're not required, but I put the link in the chat. And if you were to leave a kind, positive review, I'd be very, truly grateful. And again, I'm here every Monday. It's difficult. We're not going to solve all the answers here right now at this moment, but at least I could provide you a little bit more insight from a legal professional to tell you how I may interpret this, how I may evaluate it, and it may enlighten you so that things become a little bit more clear what's happening here. Okay, one step at a time. More things will be revealed. I do think in your situation, time is important. We have to be mindful of the statute of limitations. You got to get your full contract. You can't just skim it. You got to review it, and I would have it reviewed by a legal professional, because that is the basis of your claims. That's the foundation. You want to argue attorney's fees? Well, does it mention it in the insurance policy contract? Does it? That's something you haven't.
Yeah, I don't know.
Yeah, that's something you may want to review. If that is a main, the source of the funds, even though there's an attorney's fees provision in the contract, you're still going to have to come up with those funds. Your type of situation is, I do not see it as being a contingency fee arrangement. Now, there may be some attorneys who may be willing to do it. I don't know. We'd have to really evaluate it. I don't see it being that type of situation. You have an uphill battle, but you got to get into court. I think at this point, you got to be able to preserve your rights, because you're dealing with professional insurance carriers, and their whole motto is deny, delay, and deflect. I mean, it's all in the news. We've heard this before, where it's not a surprise. We know what they're doing. Don't fall for it.
Well, I guess I have a general question.
Sure.
Justin, obviously, as a trained attorney who's practiced, I'm sure, for many years, and I'm not. Obviously, I look at it as a pro se person, maybe someone who has sat on juries and so on, and certainly has a amateur interest in law. But now,
I also have to remind you of the expression that has been passed down over ages of time. You are your own worst attorney, and you are a fool. You have an attorney. If you are representing yourself, you have an attorney as a fool. Or how's that expression go? Have you heard it?
Yeah, no, that's a well-known expression.
Yeah.
I'm sure it's accurate. And then that's really what, that was kind of, the foundation of my question.
Are you with us? Mic check, 1, 2. Mic check, 1, 2.
If you want, let me to use the R word again, because of course that is based on fraud anyway. Now, just from a strategic standpoint, now if it were just going at it as a breach of contract and just basically foregoing, even in victory, the legal fees, and also of course the delay, which is not insignificant. You said 2 or 3 years. I always see that, that would certainly be a partial victory. But, what would be the disincentive for an insurance company to do exactly what they did in this case? I mean, even if we called it a mistake, obviously I don't believe there was anything mistake about it because of the unjust enrichment aspect, that they profited from a mistake. How is that a mistake? Certainly something that they would perhaps brag about. Where's the disincentive from, an insurance company or just any business from doing, whatever you want to call it, not the F word, some hijinks, or let's just send out an email stating something, our contract is over, and it's not really true. I mean,
the disincentive is to file a complaint and get in front of a jury and get the jury upset at them so that
punitive damage.
Punitive, yeah.
Okay. Now we're talking.
Yeah. Yes.
I like that.
Nuclear.
I guess we both brought up the P word. So, that's another, that might be the way to go. I mean, if, you know, punitive damages, because, you know, I'm really just trying to be made whole. I don't think I should be profiting from this, from their error either, any more than they should be profiting from their error. You know, I think I should be made whole as if.
But look, you would have to get into court and do some discovery, and then if you obtained some internal correspondence about them evidencing intentionality, then you can have a very good argument and good evidence to support punitive damages and to make a jury upset at them to bring back what we call a nuclear verdict. That could put a big carrier out of business. But it's very difficult. It's a long uphill battle. Brian, I do want to just bring your attention. I did put the link in the chat.
I already did a review for you.
Oh, that would be great. I really appreciate that.
But it won't show up as Brian Burke. It came up.
No, well, that's okay. That's okay. I really appreciate that. That's something that really means a lot to me. So I really do appreciate it.
And I appreciate your time, Justin. You've been very generous, and you know, obviously it sounds like you're a very good attorney, and you know, obviously getting to the gist of the matter and really boiling, you know, obviously I could, you know, make dreams all I want of, you know, and I understand, you know, I actually have done RICO's pro se, and I see how angry the judges get at those cases. They seem to twist themselves in a ball in order to not give you the case and to throw it out. So obviously, you know, I certainly wouldn't want to go strictly on that anyway. I mean, even if it was just up to me.
But you know, for instance, I mean, this was a whole issue with the whole P. Diddy case. You know, was this RICO? You know, like, is there? I don't know if you follow that in the news, but like
I did. No, I live in Manhattan here. Yeah. I was wondering if I was going to get called for the jury, but
yeah, they're like, we got to prove the RICO, the underlying acts.
Well, I think he got a friend. It turned out he had a friend, you know, an admirer on the jury that I think was really threw a shoe into the machine.
Yeah, but when you're dealing with RICO, you got to prove cases and cases within a case. True. It's just you want juries, you know, want to keep it very direct, simple because they want to provide justice and they want to be certain. Yeah. RICO's too, like, was there this? Was that? What happened underneath it to support this? Were there other actors? Were they in agreement?
I mean,
how are you going to?
I'm more thinking that it's more as a negotiating technique, frankly, just mentioning the possibility, because, you know, I do think
it's going to back. It seems like it's only backfires. It only backfires. And look, I've pled RICO cases before too, civil RICO. It expands the case so much, it will make you go crazy.
Yes, it does.
No, that's not how you present a case. Nice breach of contract. One paper, ladies and gentlemen, is based on this document. And look, I get attorney's fees. It's all here in writing.
Well, I'd love to have it done by settlement in negotiation. That's why I thought at least bringing it up, you know, say on a letter or something, that, you know, this possibility at least exists, you know, that, you know, say if you wrote it and you said,
in my experience, it just never helps. It's not there. I've never really experienced a successful RICO claim. My personal experience.
There is definitely a tough, you know, I can't say I've won any myself. So
and then the vast doors that you open to discovery, and you're thinking about resources, you would be drained trying to argue a RICO claim. I just would discourage it. I would scrutinize it very carefully. I think a very nice, clean. Don't be in. You know, don't feel fraught about just having one nice breach of contract, one claim.
Well,
3-page complaint.
With punitive damages, I think that,
Yeah.
it comes out to be the same thing.
Well, breach of
get to the same
contract, you
point.
can't get punitives on a breach of contract claim. You have to plead an ancillary tort, which would be fraud. It's usually pled together in order to
Right.
bring in the punitives. But the strong claim, look, the strong claim, breach of contract.
Okay, yeah. No, with a fraud complaint, yeah, I think that would probably, what I wanted to bring in really, because and again, I'm actually respect your opinion, and I think, you're probably more correct, as you say, because, I have a complete bias on this, obviously, I'm the injured party.
Well, because,
So,
and then that's also, again, why I suggest you work with an attorney, because you are involved in this. It's very difficult to take a step out and view it objectively, because you're in the midst of it. You're like, I want to get them with RICO. They did this, they did that, the fraud, and look, we got to just, take a deep breath. Let's take a step out and look at the big picture and really understand how others are going to view the situation. Now, look, other attorneys may differ in their opinions and their the way they handle things. All right. I always suggest to all my clients, consult with as many different attorneys as you can and try to somehow come up with the consensus. But I would be very hesitant to try to pursue the case on my own as a pro per. First of all, the court is not going to be on your side. I mean, yes, the doors of justice are there for us to open. Yes, you can represent yourself in a civil matter in pro per, but the judges are going to make it very difficult. And if they can, they will try to process the case. That's what the judge is doing with their docket. They are processing cases. And if there is a way they can get the case closed, they will do it, especially with a pro per. And the attorney, the judge at some points may even just be very clear, like, tell you need to get a lawyer. All right.
Yep.
So
no, I can't see doing this case as a pro per or pro se. I mean, I definitely want to be represented. I would, prefer, I understand, why attorneys may not want to do it that way, but, if I can get someone on a contingency or even part contingency, I love to get somebody, have, I have, experience with both, and, mixed, I just, like to have a shared, incentives, basically, and, obviously be on the same team, because sometimes, it might appear to be cross purposes, if, if both the attorney and the client, gain from, victory.
I understand that. Let's take it one step at a time, with the understanding that time is of the essence. So get your full insurance contract and let's have that reviewed. All right. And I know you may have it, locate it and review it thoroughly. And let's have that reviewed by a professional, because that's the foundation. All right. You may have some arbitration procedures in there that you have to comply with.
Good point. Yes.
And I don't look kindly at arbitration provisions.
Well, here's the one point, Justin, on this. And, I think that's a brilliant pathway. It may be the correct pathway with this breach of contract. Is that it's just, I know so far, because obviously I went with them to the insurance commissioner, and their position is that right now I have no contract with them. Obviously, it's not disputed. I had one from December 7th of.
Well, that's why you need to file and get a declaratory relief, a declaratory order that you did have a contract. They didn't properly cancel it, and it was effective, and they're breaching it.
Okay. Yeah. No.
Well, let's do it one step at a time. I'm here every Monday. We do like to keep these meetings relatively brief so we can take action for the week ahead. I believe I've tried to lay out a number of steps that you should take. Most priority is obtaining that insurance policy contract and reviewing the language with a critical eye, okay? And possibly having that reviewed by a legal professional. But I'm here every Monday. It's a good place to tap in and see what progress we make. But understand, time is of the essence. But more will be revealed. Do that step, and the next indicated step will be revealed, what to do next. I can't really, we're speaking a lot in hypotheticals because we don't have that contract in front of me. So let's do that. You feel free to reach out to me off of this platform during the week. I will put my email in the chat. It's justin@thesterlingfirm.com. I will also put my direct number. You can call or text me, 310-498-2750. I review and respond to everything. So please reach out. I'm here to be of assistance. And like I said, more will be revealed. I'm here every Monday, and we should adjourn now. It's been over an hour, and so we can take action. I think you have some important things to get done within this week. Sound fair?
Excellent. I really appreciate this. So this week, I'm just gonna review the policy, and, maybe I can join you then next Monday, and I'll tell you what, and then we can go from there.
Yeah.
Obviously, as you said, there's some deadlines, but,
yeah, I really appreciate that. And
yeah.
look, I know you said you left a review, but please feel free to invite others. And I put the review link in there. And yeah, I work for positive reviews. I'm here every Monday, and I care about what people say about me, and it means a lot to me. So I really appreciate you
Well, you've
leaving
been
me a
very
review.
generous. We took a pretty deep dive here. I think you're very generous in doing this part of anywhere is pro bono. I certainly appreciate it as someone who's already benefited, from your help. And certainly, I definitely want to, keep you into the loop here. And obviously, you came up with some original ideas, legal ideas that really, I don't know, maybe other people were thinking breach of contract. I don't know if they ever said it to me, but obviously, that, as you said, a potential declaratory judgment. I think this definitely is. We're in total agreement. It's going to have to go to court, but just I guess the exact statutes and so on that how we prioritize it, and certainly how any agreement that I would have with a specific law firm on it would be another issue.
Yes,
But
sir.
I think we did a lot of progress here, and you've been very. At least I do have a case. Obviously, if I told you what I told you is true, of course, you haven't confirmed anything, obviously, but obviously the policy is really key. It and and I could get back to you, and even if we agree, I could forward it to your firm, or maybe you think someone else would be even maybe better for this. I don't know.
Well, one step at a time. Let's get the insurance contract together and make sure you have the full contract, all schedules, exceptions, exclusions. You're going to have to call the carrier and make sure you got it. Okay? Let's do that first, and then let's touch base. But for now, let's take care. Let's adjourn and take action. Okay?
Yeah, and we'll talk next week. Thanks a lot.
All right. Take care. Take action. Thank you. Bye for now.